Hello, my name is Erica Agello, and I am the appointed special magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authorities set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach, and I do not represent the city here today. I also do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they may appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, the city has the burden of proof, so the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy. So please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether the city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subjected to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. And for those of you who brought counsel, counsel need not be sworn as they will not be giving testimony today. Unless you will, and then let me know as you approach the podium. Okay, so we will move on. The changes to the agenda, my understanding is item 3C on the case, or on the agenda, case number 2024-0475, City of St. Pete Beach versus Bayside Shops, LLC. We will be reserving time for that. That will be the last case to be heard today, is that correct?
That is correct. That would be under your cases, and then we would have the lien reduction following that.
Okay, so we want to hear the Bayside Shops after the lien reduction case or at the end of the cases on the agenda?
I think at the very end.
After the lien reduction?
Yes,
okay.
because of the change in magistrate.
And just for the benefit of the record and the public, the reason we are moving that case to the end is because I do have a conflict of interest or a potential conflict of interest with the attorney representing Bayside Shops. And therefore, we will have another magistrate take my place. So after conclusion of the regular agenda, except for that case, I will excuse myself and another magistrate, Mr. Tom Thanis, will come and take my place, and he will hear that last case on the agenda. So any other changes to the agenda this morning?
Yes, Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. We would like to add case number 2022-0159 for lien reduction order from Special Magistrate Tanis after.
Okay, so
He's heard 20.
That previous case before, okay.
2020.
So then there will be, we will proceed through cases 3A, B, D, E. Okay, and then lien reduction 8A, and then there will be, we'll take a brief recess. Mr. Thanis will come back here, 3C, and then the new lien reduction case that you've just added. Is that correct?
Thank you.
Okay, perfect. Okay, so moving on to the first item on the agenda here today, case number 2024-0089, City of St. Pete Beach versus Patrick Thomas McNulty and Annette Weiss McNulty.
Good morning, Madam Magistrate. Stephen Rivera, City of St. Pete Beach Code Enforcement. This is a status hearing for the 90-day extension to secure a permit for the driveway at 104 64th Ave, I believe. Yes. They are in compliance. They did get the permit. Get the overhead, please. Just does show that it was issued. So they are good to go as far as the permit is. The city is not seeking any fines, however, we are looking for the $330 for administrative costs.
Okay. All right, are anyone on behalf of the respondents here today, either Mr. or Ms. McNulty? Mr. Rivera, did you have an opportunity to speak with them at all prior to the hearing?
I see Mr. McNulty in passing. I did tell him, as long as the permit was issued, that I wasn't going to be seeking. I just wanted him to get the permit.
Understood.
And he was trying to do what he could. We had some hiccups with the city, with the hurricanes. So we were willing on working with him. He just had to get the permit.
Okay. Since no one since no one is here on behalf of the respondent, I am going to find that the property is now in compliance with my previous order in the city's code. I will not be issuing any fines, but I will be assessing $330 in administrative costs of the city. All right, moving on to case 3B, case number 20240157, City of St. Pete Beach versus 1008 Airport Road LLC.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. As you know, this is a status hearing on a 30-day extension to secure the dumpster permit before 3/14. That was done properly. So the property has obtained the dumpster enclosure permit and is now in compliance. I think it was the property manager spoke before, they want to get some things done in the property itself since the hurricanes, and then they're going to work on that dumpster enclosure, so they have that good time frame. I think it's about 6 months for the permitting process to keep that open before they have to get any inspections. So as long as they're following that guideline that we have instilled through the building department, we're perfectly fine, and the city will be asking for $329 for the administrative cost and no fines.
Okay, so at this point, if the property is in compliance with this particular code violation, you're stating within the next 6 months, if they don't comply with the terms of the permit and you granted extensions, et cetera, you might bring them back to?
Yes,
Okay.
yes, ma'am.
Understood. Okay, anyone here on behalf of 1008 Airport Road LLC? Okay, finding no one. I will find that the property is now in compliance with this magistrate's order as well as the stated code sections. I am not going to assess any fines, but I will assess the $329 in administrative costs of the city. Moving right along to agenda item 3D, case number 20250148, City of St. Pete Beach versus 2500 Sunset Way LLC.
Good morning, Special
Ayako.
Magistrate.
Ayako.
Should we ask if she would like to stipulate?
Your Honor, so there is a second case, which is a different property address. They are adjacent one to the other, and they do have counsel present today representing both of those property owners. I believe that one of the property owners was agreeable to stipulating to the violation. And if that is the case, if I could ask counsel that's present representing them.
Brandon, representing both those property owners, they are adjacent, and I'm not clear on what that stipulation is going to be, so I'd rather make her a little presentation and see what the magistrate has to say.
Okay, and even though you represent both property owners, we are going to be, you prefer we take these separately? I think for due process, we should take them as separate cases unless your clients have agreed to.
It's the same fact pattern, it's all one, six of one, half dozen of another.
Okay, so your clients are comfortable with, okay, and then the city's okay with that?
Well, no, I agree with you. I would prefer to do them separate. It was just my understanding that one of them was agreeable to stipulating to the violation itself, and that we would only be talking about possible fines
On a single case, but,
on a single case. But if that's not the case, we can proceed forward.
okay. So we will then go ahead and proceed forward as individual cases, and if need be, once we get through the first one, if you change your position on stipulation, we can certainly do that. Okay. So proceeding with the 2500 Sunset Way LLC.
Okay, so good morning, Special Magistrate Ayako Rakdashal, Code Enforcement Officer, representing the City of St. Pete Beach. This is case number 20250148. The respondent is 2500 Sunset Way LLC. The violation address is the same, 2500 Sunset Way. Violation description: the property is in violation of Section 25.9A and B. A permit is required, and Section 94-7A to F, where vehicle permits of the Land Development Code and the Code of Ordinance for the City of St. Pete Beach. For the case summary, the initial inspection was made on February 19th, 2025. It was determined that it was irreparable and irreversible damage. Violation was dated February 21st, 2025. Notice of hearings was dated and posted on the property February 21st, 2025. Here's a picture of the affidavit of posting at 2500 Sunset Way. This is the property, the clear vacant property. This image shows the vegetation that was established and how it has been reduced through the center there as a pathway through. This shows the track marks on the sand that was used by the tractor. And this shows you a distant view of how from the vacant lot they rode through the dunes. Another picture of the vacant property with the image of the tractor in the rear corner. Damaged the vegetation. That is an image of the tractor that was used. So the corrective action that the city is seeking is the existing dune system has been damaged and this is prohibited. The recommended fine is $5,000 per violation, totaling $10,000, plus $6,966 of cost of repair per property, plus $330 for administrative costs and any recording fees associated with the case.
Okay.
That
Can you please
concludes the-
explain to me the request for the $6,966 in repairs to the property and evidence of such?
So if I can get the overhead, please. So we had requested an estimate be provided by the Public Services Director, and this is the estimate that he came up with. It is a collective estimate for both properties. Like I say, these cases are similar, adjacent properties. So the total came to $13,932 for both, divided by 2, so that's where the $6,900.
Okay, and is this for the city to abate the property?
Yes.
Yes.
Okay, and have you,
Please show the, how that was determined, the cost.
well, and my question is, has the city already abated the property?
No.
No, ma'am.
Okay, and has the city given, clearly at this point, you've not given the opportunity to the respondents to abate the property on their own?
No, ma'am.
No, we do not wish
We
to.
do not want them back in the dune system. It's a prohibition.
And is that their private property or is that public property?
That is the city, the dune system is city-controlled and maintained.
Okay. And do you have any proof of that? A survey of the property or anything like that that demonstrates where, based on the photographs, I can see that there was destruction, but I don't know if that was private property, where the dune system starts. I mean, I saw tractor marks on the, what I could assume was maybe the parcel. But outside of that, aside from that one pathway, is there any other demonstrations on who owns that property?
We're going to try to pull up the property appraiser's website.
It
Okay.
is in the file record, the property appraisers. But this is, we did ask for Camden, the Public Services Director, to be here today to explain how he came up with his estimate. Unfortunately, he has a conflict this morning, but the repair estimate was based on approximate field measurements and unit prices for a recent dune restoration project.
Okay.
So that's how he came up with those numbers.
Okay. All right. Anything further from the city?
Out of this
No.
time.
Okay.
That concludes my presentation. Thank you.
Counsel, on behalf of the respondent?
No questions at this time.
Okay. Do you have a presentation or that you would like to make or call any witnesses? Okay, please go ahead and come forward.
Thank you. Good morning, city reps, and good morning, magistrate. My name is George Gramling. I represent both respondents, 2500 Sunset Way and Hunter Beach LLC. We're talking now, I understand, just about the 2,500, but the facts are more or less the same. So I would start by telling you, we're not contesting the allegations. We're not admitting them. We want to work towards a resolution. The city knows this. We've been in phone conversations, meetings, and so on since we got the NOV. And there's absolutely no defense here on the question of a permit was necessary. What we didn't have was the permit, but what we did have was good intentions, a belief that the activity was authorized, a lifetime regarding of respecting the law and the environment. And we thought, the respondents at least thought they were able to do this activity with no permit, partly in reliance on a Facebook posting that the city made. I'd like to introduce that as Exhibit 1. Josh?
You may, if you guys want to put it on the overhead.
And we're not going to spend today defending the need for a permit. We're going to concede that for purposes of working this out. But this shows you, this was the city's Facebook page 4 days after Helene. Can you see it?
I can.
It says, to me it says, and this is my opinion, you can return sand to the beach from your property, which they did, and you can use mechanized equipment, which they did. Where it says that, where does it say that, Josh?
I read about that.
Here it is, heavy equipment. So after phone calling and emails and so on and so forth, which we don't want to belabor, they did it anyway, no permit, okay, fair enough. So here we are. I've been trying to settle this thing, so let's go forward with the crux of the matter. And the crux of the matter is, although unauthorized disturbance of dunes is a serious offense and it cannot be sanctioned and we do not condone it, we're not defending it. The scale of the enforcement should be commensurate, in my opinion, with the harm, if any, to the dune system, and I would like to address that. I myself am not an expert in oceanography or wetlands or any of that. I am an environmental lawyer, and I don't know that the city has brought anybody to the table who could give you a true understanding of whether there's been harm. Do we need restoration? Has there been damage? Is it irreparable? Is it irreversible? So I brought an expert. And with your indulgent magistrate, I'd like to introduce Brittany Banco as our expert. She's got a PowerPoint presentation, which I think puts this in context, hopefully. I provided this to Nancy in the city a week ago. They've seen it. There's no objection, I'm told, to introducing Brittany in her testimony. So if we may do that now?
Absolutely. And is that true representation? There's no objection?
Yes.
Okay, of course.
A lot of this is going to be repeated on the next property, so you're hearing the story.
Well, I don't have a problem once we make it through
Okay,
this. If you
sure.
want to just go ahead and adopt the evidence that was submitted in
Got
this
it.
case for the next case, that's perfectly fine, as long as the city doesn't have any additional questions.
I skipped one point in one exhibit. So back to the crux of the matter. My reading of the code is if the magistrate finds that the damage was irreparable and irreversible, the max fine can be levied. That's $5,000 per. They've shown you that with $20,000. But that's the case they have to make. And so the only person here who can testify as to the damage is Ms. Banco. We'll hear from her right now. But the code doesn't define irreparable or irreversible. And the only thing I have is Webster's Dictionary. I'd like to introduce that into evidence.
It's not necessary to take into evidence, but you certainly can.
Okay, well, it's...
I believe the
I'll kinda
case
know
law
what it
bears
means.
out, yeah, but case law bears out pretty substantially what irreparable or irreversible
Okay,
is. But
fair enough.
please, this
No.
is your case to prosecute, so if you feel that's necessary, you may go ahead
I'll
and
skip
enter.
that. And I will turn the podium over to Ms. Banco if that's
Of course.
Brittany?
Good morning.
Good morning.
I'm Brittany Banco. I'm a senior ecologist with Verdantis LLC. I've been brought on to assess the dunes for the respondents. Let's see here. So this is just a little bit about my professional qualifications. I have a Bachelor's of Science in Environmental Science and Policy from the University of South Florida. I'm a certified professional wetland scientist from the Society of Wetland Scientists. I have 16 years of experience in Florida ecosystems. Qualifications include environmental permitting and compliance, wetland delineation, restoration, mitigation, and evaluation, aquatic system evaluation, wildlife ecology, and permitting. Prior to being in the private sector, I also worked for the Department of Environmental Protection, and I had done some compliance on coastal projects. On the side here, I have a little bit more information. I have living shoreline training, swift mud wetland assessment procedure, MSHA certified, qualified stormwater management inspector, SSI open water diver certification, permitted gopher tortoise agent, and I'm a member of the Tampa Bay Association of Environmental Professionals, Florida Stormwater Association, and the Florida Native Plant Society. So the scope of our evaluation included an on-site inspection on March 11th, 2025. We collected some data using a Trimble GPS unit that has sub-meter accuracy, and we assessed the most waterward limit of the dune, and then we overlaid it on some LiDAR maps and aerial photography that are pre-storm and post-storm. So this is a photo taken from 2502 Sunset Way facing the water. This is their pre-existing path that led from their home out to the beach, and you can see that there is vegetation throughout outside of the walkway.
And this was taken pre-storm?
This is post-storm. These photos are from our evaluation on March 11th.
The post-storm, okay.
This is a side view of the current dune at Sunset Way Properties. This is a current view of the pathway. Oh, sorry, I'm going backwards. This is the opposite side of the pathway. The dunes are clean. There's no storm debris or anything, no stains, no odors or debris were observed within the properties or the proximity of the properties. These are photos taken of dunes located further north, just to kind of show that these properties look very similar to the other properties along the beach. This is another example of that. So visual map comparisons. You can see here the pre-hurricane that was taken in 2018. So that pink, the brighter pink area is the higher elevation. The properties are the two in the red box. So prior to the storms, there were sort of two distinct dune systems, and if you can see those blue points, that's the data that I collected on March 11th using the Trimble. So that is sub-meter GPS accurate, or sub-meter data of where the edge of the sand dune is today. So post-hurricane, that was collected by the Army Corps of Engineers on October 26, 2024. So you can see that the storm had done some significant damage and kind of moved a lot of the sand around. The hot pink, or the brighter pink area, is the higher dune elevation. So you can see it went from two distinct dunes sort of to one flatter dune area. You can still see the pathways are present. And those blue points are exactly where the edge of the dune is today. So this was taken October 2024, and the data of the blue dots was March 11th. So where the dune is today is pretty consistent with what it looked like post-storm. These are just some pre and post aerial photos, so you can see what it looked like. The blue dots are on there as well. You can kind of see it's consistent within what's west of these two properties and the properties located north and south. So we just have a few summary points here. So Hurricane Helene and Hurricane Milton devastated the sand dune system along St. Pete Beach, including the dunes at 2500 and 2502 Sunset Way locations. The dune system has gradually recovered to a healthy and functional condition through natural forces, including natural vegetative recruitment. Nature will continue to restore the dune system without human intervention or restoration. And based on my physical inspection of the dune at these properties and my professional experience as a biologist and wetland scientist, the dune system has not been irreparably or irreversibly damaged by human activity. And that is it.
Okay, thank you. Does the city have any questions?
I do, just a couple. So is it your testimony that there has been absolutely no damage at all done to this dune system by virtue of the heavy equipment?
I can say that there were tracks that are out there, but these systems are not really static systems, and they're really wind and water driven. So there may have been some temporary impacts, but I don't think that it is a permanent impact to the dune.
Okay, so let me make sure I get this correct. So the presence of tracks, which you've agreed has existed based on the photographs, that instance in and of itself, did that damage the dunes?
It was probably some temporary damage.
So in your opinion, is temporary damage repairable?
Yes.
Restorable?
Yes.
Even though once the damage occurs, it happened.
Yes.
So that damage in that instance is not reversible because the damage occurred.
I would say no, only because it is like nature, you know, these systems move around, although it was maybe some human interaction with the intent, like some positive intent behind it. From the photos from City of St. Pete Beach, it already doesn't look like that. The tracks are gone, there's vegetation, there isn't a significant impact to the dune.
But when the tracks were made, there was damage that was done.
There may have been, I was not present.
Okay. The fact that, could you give us a better understanding? You're saying that over time that the dune will basically repair itself. How much time are you considering? What is your opinion on that?
Well, it really depends. It depends on storms, it depends on if we get another hurricane, it depends on human intervention post, you know, before another storm comes. I know that there's been some concern with people on the beach walking through there currently because the dune system is just flattened a little bit, so there's a lot more human traffic.
So it's possible that that dune may not be restored to the condition that it was.
Possibly, but I believe most of the damage was hurricane related and not from the tracks.
Okay, but your testimony is that because of the tire tracks, because of the presence of the heavy equipment, there was damage.
There could have been.
Could have been or was?
I'm really only going off the photo that she showed in my mind, so.
Okay.
There could have been a little.
But you did testify that you did go to the property, correct?
I did, but in March, so I didn't see.
So you weren't there when the actual damage occurred?
I was there after the damage, or after some work had occurred.
Okay. All right, that's it.
Okay. Ms. Banco, do you happen to know the extent of what you just described as work that was done at that location was?
We didn't map out anything, pardon me, but really all we collected was some photographs of the general condition and compared it to the adjacent properties, and then we collected the landward extent of the dune so we could compare it to, you know, following the storm, was there less dune or more dune? And based on the data that we have, it is consistent with what it looked like right after the hurricane.
Okay, and that's what my next question was going to be. You inspected visually in March, but your LiDAR maps were from October?
Yes.
Okay, and that was after post-Milton or just post-Helene?
Post both. So Helene was in September
Right.
2024, Milton was October.
Okay. Okay. I don't have any further questions. Do you have any follow-up questions?
Not for this witness, but I would like to call our code officer back.
Oh, of course. Before we do the code officer, does the respondent have anything further, any further testimony, evidence, or presentation you would like to give prior to the code officer being recalled?
Before closing,
Sure, please.
thank you. Well, we heard the testimony, and you heard us say that we're not really here to contest or fight about the violation. It happened. It was a mistake. We saw the Facebook page. That said, I think the natural recruitment lay opinion will take over, and this is not worth restoring in the sense of human interaction. It's not necessary. However, if the scientists disagree, and that's what we do, we do. as I said earlier, the magistrate certainly has authority to fine the respondents. If that happens, it happens. I would mention that the respondents have no track record, no history of anything like this. They are permanent citizens and good citizens of St. Pete. They respect the environment. They're very contrite about this, very sorry this happened, and are willing to, do something to make it right. So today, we're hopefully looking for a resolution outcome, finality, whether it's get fined, don't get fined, write a check, whatever it is, and that's hopefully where we'll end up today.
Okay, I guess I have a question too, and I know there hasn't been any testimony to this effect, but just for my edification, the photographs from the city seem to appear to show a tractor clearing a vacant lot and pushing sand out into the dunes. Can you maybe explain?
Thank you, yes. May I offer my assessment of the photographs? Okay, the lot in question is 2,500. That is a new house going in. That's a permit. It's been issued. It's been designed. It's got an architect. It's got a permit. That upland lot has nothing to do with this. I don't know why that photo came in, but it was part of the packet. So that, I respectfully suggest, should be disregarded. The Bobcat is the Bobcat. You saw that. And my understanding of what happened, and I will confess I do not have every fact at my disposal. I don't think it's worthwhile to rehearse it all. We don't have it here today if we need it. But my understanding is, based on the Facebook, sand was moved from point A to point B on the beach, and from the backyard or the walkways of the existing house at 2502 to the beach through that little pathway.
Okay.
That pathway's been there for 57 years. And the property boundary that I know we're interested to know, I happen to have, if I may put this up.
Yes, please.
I won't enter it because I think the city wants to, but
Okay.
every single house has a path. So the path per se is not I don't think the city's arguing that the path is anything, right?
I don't believe so. I think the path is permitted, my code officers,
So at the end of the day,
if I can confirm that.
Well, and you can recall him and ask him that question.
at the end of the day, the dune system all up and down, north and south, all the way to the Don and back looks the same to me. It's ubiquitous. It was severely damaged by hurricanes, not by us, and it will naturally recruit and restore. So,
Your
having
Honor,
said
I think that counsel is now providing fact-based.
He's not providing,
I'm not-
he's arguing, and I understand he's not under oath, so I'm not taking these as testimony or fact to consider. It's just to get context.
And we want to work it out. We're not interested in a contest over the right or wrong or any of that, so
Okay.
thank you.
Thank you very much. And Ms. Dubrick, you wanted to recall the city's code officer?
I do, for a couple items. First, if I may, ask the questions regarding the survey and the extent of where the city's property begins and the damage in the dune area.
Thank you. Madam Special Magistrate, you asked about the dimensions and if the property extends beyond where these red lines are. As you can clearly see, that's their property boundaries, and we know that this is not entirely accurate, but this is the closest we're going to get, including this replat of Sunset Park. The lot in question is 5 right there, and this is a close-up of that lot. As you can clearly see, the dimensions are 110 through 50, or 110 by 50, and it does not extend to the mean high water line. So it does not extend beyond what you see here on the property appraiser's website.
Okay. That is very helpful and clarifies quite a bit. Thank you.
Thank you.
And then did you have any follow-up questions?
I do. On the estimate that was prepared, could you again, for the record, state who prepared that estimate?
Camden Mills, Public Services Director,
And why was Mr. Mills asked to prepare that?
because he had done some previous restoration work that was required on our beaches, so he had an understanding of what additional work would be required, what contractors, et cetera.
Is it your testimony he has a history of providing estimates of damage? Okay. And could you, when did he go and provide the estimate?
That came, last week. It doesn't have a date on there.
Well, let me change the question then. So as a code enforcement officer, you believe that there is damage there?
Absolutely.
And you did consult with Director Mills to verify that, in his opinion, there's damage there?
Well, I met with staff out there and to take measurements to quantify, if we could, what restoration would be needed.
And can I ask a follow-up
Measure the
question?
area.
In speaking with Mr. Mills, and I don't believe that you've given any of your background to solidify that you have any type of specialized knowledge of the dunes, but giving Mr. Mills, your conversation with Mr. Mills, what do you know what the damage, was the damage caused by the hurricanes? Was there additional damage caused by the property owner? What was the genesis of the damage?
Well, I think when you have damage from the storm, it presents as a uniform sort of decaying of the dunes, and you can clearly see that the high ridges of the dunes, as shown in my pictures, and a hollow that was created, where you see the plants where vegetation was suppressed, rode over with equipment.
So the city's position is that the sand that was cleared from the properties through the dune system to the beach on what had previously been a pathway but then became some sort of accreted dune, that is damage to a new dune system that was caused by the hurricanes?
Well, it's the decaying of the previous existing dunes, so therefore...
Right, but the previously existing dunes had a pathway cut through them.
True.
So the storms changed the nature of the dunes. I'm just trying to figure out what exactly is the mechanism for the damage.
The equipment that had to traverse into the dune to get to the other property to move the sand.
Okay, so the pathway through whatever was created, the damaged dunes that was damaged by the hurricanes is now being further damaged by
Absolutely.
cutting a pathway through them.
Yes.
Okay, I think I understand the city's position.
That estimate came on April 5th, by the way,
Thank you.
from Mr. Mills.
Any further questions from the city?
No questions.
Absolutely. Yeah, if you can come to the microphone and you guys can just switch off. That way it's both on the recording.
On the question of damage, could you describe it? Did you see it?
Yes.
Broken sea oats?
Yeah, suppressed sea oats.
You're talking about the path mainly, I assume?
No, this didn't look like there was an established path there at all. This is clearly just to exit the vacant lot with the
Okay.
tractor to go around to the property 2502 and clear the sand.
And then here's the Facebook page. Have you seen this before?
Probably, yes.
So does it say return the sand to the beach? That you're allowed to return the sand to the beach?
Yes,
And
I
use-
don't
use-
think it
use
does
heavy
mention that you can go through the dunes to do that.
How would you do it?
Hand and shovel, I don't know.
It says use mechanized equipment. Oh, well. And I know you're not here as a scientist, but I may ask you. I've never seen that estimate. I still haven't seen it. How big is the other area for restoration that the city is advocating? Just our lots, or just the city lots, or the whole?
Just the area in front of 2500 and 2502.
So right here, this is city property in the red. This red box is the city-owned dune system. Here's the respondent's property. Where are you talking about? Would you point it out, please?
Okay. The repair was based on approximately field measurements that aren't quantified here, and unit prices from a recent dune restoration. The estimated cost of materials, sand, and plantings is approximately $1,615. The remaining costs are for mobilization, erosion costs, and surveys. Those costs will likely fluctuate depending on contractor's use.
I do have another inquiry, and I apologize to interrupt your cross-examination, but the estimate that you're giving, that the city is giving, includes plantings. My understanding is from the storms, the dunes came in and covered what vegetation was there. Otherwise, that vegetation moved because of the water coming in and moving the sand. You're stating that the damage caused by the tractor putting it back out to the beach, then further, they were fine with the sand covering them, but now that the tractor went out, they are damaged, that they need to be replanted. My concern is, and let me kind of get you where my brain is going here. My concern is there was damage caused by the hurricanes. And what I am understanding from this estimate is the city wants to put back the dunes back to the way they were prior to the hurricanes coming in. So what damage was caused, if damage was caused, whatever damage was caused by the property owners, the city is seeking far in excess of the damage caused by the property owners, and instead is seeking to put the dunes back to the way they were pre-storm. Is that not the case?
So the storm ended in, the last one in October, right?
Correct.
By the picture, we can see that there was established vegetation growing through. We're trying to recover, as the beach is trying to recover on its own.
And this was February of 2025, this picture was taken.
Correct. So there was vegetation growing uniformly throughout that dune, and you can see clearly that the tractor rolled over it and damaged the dune. So that is the status of which we would like to return it to.
You're not seeking to rectify it to the pre-storm?
Pre-existing hurricane, no. It was much higher in elevation, it was more established, but
And do you know what date the property owners allegedly damaged the property? I don't have the date of the violation, I just have the date of the initial inspection.
right, and this came through a complaint that was passed through to code enforcement,
And what date was that complaint made?
probably a couple of days before I actually went out there. So I went out there on,
I think your picture's dated February 19th.
yeah, so 2 days before that, I think we received the complaint, and then I went right out there and took the pictures and posted for the hearing the same day. And I do have here the estimate area that was, if I can go to the overhead, again, sorry. To quantify the area that he has based the assessment on in the column here.
And we've got charges for signage, we've got charges for rope and post and beach access. This estimate, and I wish I could question Mr. Mills, he's not here, but this estimate seems to include things to put the dunes back pre-storm, not pre-quote damage. I think I have enough. Does the city have any further evidence it would like to present, or any further questions?
No,
Argument?
Your Honor.
Okay. Okay. And I didn't see or hear any testimony. I only saw one picture with regard to vehicle permits. I'm assuming the vehicle tracks is what you're saying. That's the evidence of having heavy machinery on the beach that didn't otherwise have a permit associated with it. Is that correct?
Correct, and the construction company confirmed to me when I questioned them, because the owners weren't available, that it is not their tractor. It didn't belong to the construction company. It belonged to the neighbors at 2502.
Okay, so do we know whose tractor it was, and are we for sure? I mean, obviously, there's something
My
that drove out on the
understanding
beach,
is-
but do we know what vehicle drove out onto the beach?
I'm assuming it was a little mini tractor, and you can see that the tracks are a little mini tractor, comparable to what we saw.
Okay,
On the site.
so you can't confirm that, but based on the pictures and the tracks on the sand, you're making the
Correct.
connection. But,
Correct.
and you do know who that tractor was, that was on the property for 2,500?
Yes, the construction company said it did not belong to them, and it was owned by 2502 property owners. And they had
That's my
asked,
question. Which of the properties are you assessing the vehicle? Because obviously, there are two cases here, 2500 and 2502. So one of them is saying that the tractor's not theirs. One of them is saying the tractor is theirs. You
But
have
it
two
access-
You have two code citations here, one for permits for dunes and one for permits for vehicles. I've not
Correct.
really heard a lot of evidence to support the violation for vehicles. So I'm just trying to see who that is specifically against.
the tractor belonged to 2502. They had accessed the dune violation through 2500. So by 2500, allowing the tractor to come through their property makes them also responsible for allowing a vehicle to come through unpermitted onto the beach.
Okay. And you have proof, you made an assumption that that's what happened based on the tracks on the ground?
Correct, and by what the construction company had told me.
Okay. Anything further from the respondent?
No, I
To that.
wish we had more facts, but it's almost at a point where it's not worth it. I will say two things. One, the tractor, it's my understanding, was not owned by anybody. It was rented, and not by 2500, by the adjacent owner.
Okay.
Number one. Number two, the only testimony we've heard that, in my opinion, about the damage to the dune matters is Ms. Banco, and we haven't heard that it's irreparable, so I will rest.
Okay. And since it's the city's burden, city has last ups, do you have anything further based on that argument?
No, and these two properties are intertwined. I mean, you know, the identical
Okay.
violations.
Okay. Thank you
Okay.
very much. I appreciate that. I'm going to contend with the section 94-73 vehicle permits violation first. I don't believe that there is enough evidence by preponderance of the evidence to find that that specific code section had been violated. I believe there is some circumstantial evidence, but not enough to tell me or point to me who the violator was. So I am not going to find a violation of section 94-73 vehicle permits. As far as section 25-9 permit required, I do not believe that there has been any evidence to suggest that the parties both agree that a permit was required to either excavate or otherwise cause damage to a dune or conduct or cause to be conducted any activity, improve or enhance a dune. So I'm going to get hung up on, there's been a lot of talk about damage. I don't necessarily know that I believe that there was, quote, damage to the dune. However, that's not what the code says. The code says, in no instance shall any person, municipality, county, or other public or private agency excavate or otherwise cause damage to a dune. So the key word here for me is excavate. I don't think that there is I think both parties agree that a mechanical equipment went through what was otherwise a path prior to the storms, and the dunes coming in to fill that path went through, created a path over the previous location to dump the sand on the beach. A dictionary definition of excavate, that fits with me, so I will find that there was a violation, that no permit was secured, and there had been an excavation of the beach. Or of the dune, rather. I do not find that this is an irreparable or irreversible violation, only because the city has provided a means of abatement. I can't see how you can argue that the violation cannot be repaired or cannot be reversed when you've provided me evidence of how the city contends that it will repair and reverse the damage that was caused to the dunes. So I find that to be invalid, and I don't find this to be an irreparable or an irreversible violation. I do find that there was a violation for failure to get the permits. I don't find the Facebook posts to be relevant. Really, I think it also says that you may do this. That doesn't mean that you cede getting permission from the city to do so. I also don't find Facebook to be a very credible source, period, regardless if that post was made by a governmental entity or if it was made by a private citizen. That being said, I am going to, this is the part that's a little tricky. There is a violation. It's not irreparable, irreversible. There's no way to ask for a daily running fine because the city does not want the property owners to fix the violation. So here I am running into Chapter 162 issues that say if I don't find it's irreparable or reversible and pin a specific fine, I must then find a daily running fine or allow time to abate. But you are not letting the property owner abate the issue. So all I can request is that they fix it by going to get a permit for the work that they had done to be either granted or denied, because that is the violation that you've brought to me, is that they have failed to get a permit. They can cure and get a permit. They just can't go back and do the work. So again, I am going to find that there is a violation. I guess I will defer to the city on the means to, I'm not going to give you the means to abate because in all honesty, if I do so, I'm going to do it within a confined space, meaning you are only going to get to abate to how the property looked post-storm prior to the tractor going out there. And I am only going to allow you, I'm not going to give you any money to do so. You would have to come back and say this is exactly what we did. But either way, you're still going to have to get a permit from FDEP2, which is the solution for the violation that's at hand. So at this point, does the city have another request for relief based on the ruling that I've just made?
No, Your Honor, we do want the abatement. However, because this issue has multiple facets to it, would it be possible to perhaps continue this case and allow the property owner and the city to come back to you with a proposed resolution for it?
I would defer to the property.
I'm in favor of that. It's today. The city's had plenty of time. That's the first estimate I've seen. We would not like to continue it with respect.
Then what I will do at this point is I'm going to find that there's a violation. I am going to reserve ruling on the remainder so that I can do a little research to see what powers and authorities I have and come up with a solution. I will get an order out with regard to this property and that, and then what I will do in my order is, if need be, I will put a mechanism in there where we can, at the next magistrate meeting, we can come back if need be and discuss whatever's in there, but my order is going to stand. It will just be to discuss the mechanism for what that happens to be underneath it. Because this is an equitable process, I am trying to be fair, but I am in a position right now where I'm happy to go ahead and make the determination that there was a violation in the hearing. However, that the mechanism of trying to figure out what the either abatement or what the fine procedure would be, I just need to get a little bit more research done on that. So actually, let me walk that back a little bit. I'm going to give you guys 7 days from today's date to get me something backed by law, what you think my authority is, and what you think an appropriate resolution should be, and I will be able to get my order out to you today. That will give you the ability to come back to me, and then I can amend my order after that. I think that might be the most equitable resolution. That way we're not coming back in 30 days, but you both can get to me your positions, and then based on that, I'll issue an amended order with a final order on that one.
Including a settlement, I assume, if we reach one.
If you reach a settlement before the 7 days, just let me know, and then we'll dispense with the whole thing, but that's by and between the parties. As far as my responsibility in this process, I just need to determine whether or not there's a violation and an appropriate either remedy for it or fine assessed with it. That's the tricky part I'm having right here, just because ordinarily I would just say go get the permit and go ahead and cure the code violation. But you can't cure the code violation because they don't want you on your property. So And I'm not willing to have them abate it because what I've seen here is the abatement doesn't really constitute whatever the violation was. So to clarify, after my ramblings, there is in fact a code violation, not for section 94-73, but instead for section 25-9. And then I will issue that order today via written order. Make sure I have your email address. And then within 7 days of my order, you will have the opportunity to get to me what you believe either an appropriate fine or resolution on the abatement of the violation is. I will consider those, and in the meantime, if you happen to work out a settlement, by all means, let me know, and we can dispense with an amended order.
Thank you, that's crystal clear.
Any questions on that?
No, thank you.
Okay, and then moving on to case number 2025-0149, City of St. Pete Beach versus 2502 Sunset Way LLC. Understanding it's the exact same issue. Ms. Dubrick, do you have any concerns with us moving forward in the same manner? I know there
No,
were...
Your Honor, I think that would be a fair disposition of resolving both of these cases.
Okay. All right, perfect. So then I will do so. I will issue a consolidated order, if that's okay with both parties.
There is a correction to the record on the address or the name, Josh?
Yeah, so
Josh
on the,
Coldiron.
Josh Coldiron, for the respondent. So on the agenda, it says 2502 Sunset Way LLC, and that's not the property owner. The property owner is Hunter Beach House LLC, and it's on the property appraisers if you need contact information, but I think it's just
Hunter Beach House
just a Scrivener error on the agenda.
Your Honor, could I ask for two separate
Yes.
orders, just because the facts are a little bit different because of the vehicle?
The vehicle one?
Yeah.
Okay. Okay, I don't have a problem with that. Or do you have any objection to two separate orders?
Good.
Okay. Okay. All right, then I will get two separate orders on both cases, 3D and 3E. Like I said, I will get those orders written to you today, and then within 7 days, you'll have the opportunity to, and I'll detail that in my order so that you have that information. Okay, there are no repeat violations, new cases, or cases complied, no old cases, so moving on to agenda item 8A, the lien reduction that I'm handling, which is case number 20250089, City of St. Pete Beach versus David Tucker. Mr. Dewar?
Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. We have this lien reduction request that was provided by Mr. Tucker. And Mr. Tucker has stated the individual in front of me had 7 violations and was fined 700, or rather 500 each. I had 3 violations and was fined $1,000 each. I understand that this is because he had hurricane damage. I had damage as well and feel I should be treated equally. The city is requesting that the imposition of fines ordered, and that's your order, and your order basically says that the fines are $1,000 for 3 stays, totaling $3,000, plus administrative costs. So we're requesting that this order be upheld. Mr. Tucker's property did not sustain damage or substantial damage. Your decision is further supported by the non-substantial damage determination that was made by the city. That determination was made by the building official for the City of St. Pete Beach, Luke Curtis. And it basically says that 7605 Coquina Way has been assessed and as having sustained damage estimated to be 2.2% of the structure's value.
Any claim that Mr. Tucker is making that he has no substantial damage is refuted by the reviews that were posted after there were stays at his property. One was in October 2024, stayed about a week. And then this one was in December, stayed a few nights. As you can see, Anna and her team were super accommodating and so kind. My boyfriend and I had a trip booked. Trip that ended up failing a few days after the falling rather a few days after the hurricane, and Anna kept us up to date on how the house and the area were. We had the best time. As you know, the hurricane happened in Hurricane Helene was in September 26, 2024. Milton was October 9, 2024. There's further evidence that Mr. Tucker has never gotten if there was substantial repair, Mr. Tucker has never gotten a permit for those repairs, and we have outlined the permits that have been issued to that property all the way back. January 2024 was the last permit for plumbing issue. No permits subsequent to that. So this idea that he had substantial damage, I think it's a stretch for him to prove. Thank you. This concludes my presentation.
Thank you. Mr. Tucker?
Good morning, Madam Magistrate. Here's a sworn statement of loss. Showing that there was about $135,000 in damage. The roof lifted. So we've got two sides to this house. One side is rented out now by the month. It had no damage, but the roof itself was lifted, so it inundated the other side of the house. And we've still got hidden damage on that side we don't even know about yet, mold.
Okay, and so can you explain to me your argument for why the lien should be reduced? I guess because when I made my order and I imposed the fines, I had what testimony information that I had at the time. None of this came up. I understand that this might have occurred afterwards, but you would have known of the damage that was occurring on your property, especially a roof damage at that time. But none of that information.
I did know, but I did not hear you ask the individual in front of me if he had hurricane damage. I didn't know that was even part of the program. Keep in mind, I don't normally go to court.
Understood.
So by me not hearing that, I couldn't address it. And here's the sworn statement of damage notarized. If you want those on
And your sworn statement, is that a sworn statement of your loss to Frontline Insurance or from Frontline Insurance to you stating that that's what the losses are?
Maybe you have a copy of that one as well.
You can have copies of all of it. I just want copies back.
You got it. We'll give you copies back.
So again, my question is, are these sworn statements of loss from you
The one previous
to
was,
Frontline?
The one previous was, this is from Frontline itself, statement of loss. There's the logo at the top of it.
Okay.
And again, I wouldn't be back here, Your Honor, had I heard you ask the question about hurricane damage. I don't know who didn't have hurricane damage on this island.
Well, and I don't recall that other person's case, and I'll be honest with you, it wouldn't matter to me anyways. What does matter to me is, if I recall correctly, when I'm making my decisions, if there was hurricane loss and they were not able to repair their property or they were not able to be in their property, the city has provided a review that you were still able to rent that second part of the property, either if it's short-term or not, somebody was able to get in there after the storms. Is that true, or was that?
Part of it. Remember, it's
No, I understand, but you were able to have somebody on the other side.
on the other side.
Okay. All right, so your property was not a completely, and I think that was, and again, I'm not trying to take the other person's things into consideration, but you brought it up. I try and take everybody on their own, as I'm required to. But if I recall, they had substantial damage where they weren't even able to remedy their property. So without recalling that, I don't really want to compare the two. I just want to take what I have on face value here. You're asking for a reduction in the $3,000 based on what somebody else got. I'm not going to consider that. I might consider that you get a reduction based on the fact that you have damage to your property and aren't able to pay. It looks like you got an insurance payout. Also looks like you're able to go ahead and have somebody on the other side. I'm not saying that you didn't have insignificant damage. I don't really care about a substantial damage determination, or damage is damage. You have a property, got damage, you have to pay to fix it. I understand that. So what I see here in your application is that you're asking for a reduction in your fine to $1,500, is that correct, from the $3,000?
Yes, ma'am.
Okay. All right, and the city is not willing to do the 10% reduction at all. It's just a straight impose what was on the order from the fines, correct? Okay.
In addition to that, Your Honor, I only saw where they provided evidence of 2 references on there.
And in all honesty, nobody was sworn here today. There's not, I mean, I can take it into consideration. This is a purely equitable decision. I tend to use the same criteria when I issue the fine to be the same criteria when I look at reduction of the fine if the city's not willing to come down at all. I'm not trying to downplay your significant damages. That's $135,000 in your estimation, $40,000 in your insurance company's estimation. I know there are deductibles involved. Is this your primary home?
Yes, it is, Your Honor.
Okay, so if you're renting out the other side, where are you living presently?
It's 2 parts to the home. The other side's complete entity of its own, and our side is complete entity of its own.
Okay, but you said one side was damaged, and then you were only renting out the one side.
So the home was built in 1992. The addition to it was built, added on in 2002. That side didn't get the significant damage. Our side did. We don't know what's going to happen once they pull the roof off, which is supposed to happen this Thursday and Friday. Now, I don't know if the general contractor's pulled the permits on that yet, because he just met with me Saturday.
Okay.
And he told us he was planning on doing it Thursday and Friday. I do know that we have water damage inside of our primary residence, but we don't know what's on the other side at this point until they pull that roof off.
Okay, and so the rentable side, you're still continuing to rent, but on a 30-day basis?
By the month.
By the month, okay.
And keep in mind, Your Honor, I had a property manager. I thought I was doing everything in compliance. I didn't know. Again, ignorance of the law.
We had this discussion last time, that ignorance of the law is not an excuse. You work, whatever the fine is, I didn't take that into consideration. That's between you and your property manager. If you
Here's
want to
the
go
other-
after your property manager, by all means.
Here's the other part of it, where she's got it on her website now, 30-day minimum.
Okay. Well, and I'm assuming you'd have to be in compliance if you were here for a lien reduction. Okay, anything further you'd like to present to me today?
That's it.
All right, anything further from the city? Any questions from the city? Okay. Okay, I will grant the lien reduction. However, I am not going to reduce it to $1,500. I am going to reduce it by $500, so it will be reduced to $2,500 plus the $330 of administrative costs of the city. While I do appreciate that you've had storm damage, you were renting the other side. I know it's your home, but these were previous to the storm rentals. You were still able to rent afterwards, so I'm not really compelled to reduce it any further than that. So I will get an order out on that, and then it'll be the regular terms, which I believe is within 30 days of the order. You'll have the opportunity to pay the reduced fines. If you don't, it'll go back up to the $3,000. And if I have your contact information, I believe I already do, I'll send you the order to that effect.
Thank you.
Thank you very much. Okay, and I believe that's all for me today. So we will take a brief recess of about 5 minutes, 10 minutes, how much 5 minutes?
5 minutes.
5 minutes, and then you all will reconvene with my better-looking half, Mr. Thanis.
My name is Thomas A. Thanis. I'm filling in for Ms. Ajello as special magistrate on this particular case due to a conflict that she has stated on the record. I don't believe I need to go through the opening statement that she did, other than affirm that I'm not an employee of the City of St. Pete Beach. I'm an independent attorney who has been retained by the city to hear code enforcement cases. I believe the item that we have before us today is the City of St. Pete Beach versus Bayside Shops LLC, case number 2024-0258. I've also had the opportunity to receive an amended motion to dismiss. I'll open it up with Mr. Dewar making an opening statement and then turn it over to Mr. Denhart.
Mr. Special Magistrate Pete Dewar, Code Enforcement Manager, City of St. Pete Beach. All I'm here to do is to request. I don't know if you were in the room when we added case number 2022-0159, which was an order, actually, that you handled, a case that you handled. In this case, the respondent paid the lien reduction. We would like an order so that the lien can be dismissed. We're missing an order, so we're asking that you provide us an order.
And help me exactly what you're looking for on the order?
That the lien was, it was reduced and settled.
And then it was also paid in full after?
And it was paid in full, yes,
All
sir.
right. All right. I'll issue that order.
And
should have it
I'll,
out by tomorrow at the latest.
thank you, and I'll have Officer Cruz present the case that you just
All right.
called.
And that particular case, I don't have, it's not on the agenda though, correct? Is it?
So if I may, Your Honor, I think he's just looking for the satisfaction release that can be placed of record.
Yes,
All right.
for case number 2022-0159,
Yeah, so it's just administrative.
445 90th Avenue, St. Pete Beach.
Ms. Stuprich, do you have a form that the city uses for that? Have you had
I
that happen
don't,
before?
Mr. Dewar may. Do you have a former release and satisfaction that the
This is
city
not
uses?
for that specifically. This is so that we have this order saying that this lien has been paid.
So this is a document that's going to get recorded, it sounds
Yes.
like, to clear title.
Yes.
So you need something that's, okay, I'll issue something. If you think I need to make a revision to it, you'll let me know.
Okay.
All right, and the respondent's not here, is that correct, or is she here?
No.
All right, so I'll deal with you then.
Okay.
All right, let's start the case I referenced earlier. Mr. Cruz, good morning.
Morning, good morning. Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement Case Number 2024-0475. Respondent is Bayside Shops, LLC. Violation address is 5501 Gulf Boulevard. Violation description, the
Mr.
property...
If I could have you stop there.
Yes, sir.
I see Mr. Denhart standing. When I see an attorney standing, it usually means he'd like to say something.
I would. I do have a motion to dismiss to argue, and I thought that was going to be argued first. Ms. Jello had indicated back when she was on the case it certainly would be.
All right. Any objection, Ms. Stuprich?
No, but I believe the code officer could just do an introduction, so that way the public, everyone knows what case.
That's what I was going to do. I was going to come.
Getting into the case.
Yeah, let's get Mr. Cruz back up at the podium and then just introduce the case so we know what we're talking about. And if anybody is watching, they'll have a better understanding of the case. Mr. Cruz, please pick up where I interrupted you.
Thank you, sir. I'll just start from the top over here. This is Code Enforcement Case Number 2024-0475. Respondent is Bayside Shops, LLC. Violation address is 5501 Gulf Boulevard. Violation description, the property is in violation of Section 38.5, Prohibited Uses and Structures of the Land Development Code of the City of St. Pete Beach. Case summary, the initial inspection was 8/14/2024. Notice of irreparable or irreversible violation dated 8/14/2024. Notices of hearing dated and posted on the property 8/14/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 5501 Gulf Boulevard, August 14, 2024. This is the initial first page of the Airbnb advertisement. at the property of 5501 Gulf Boulevard. Just giving you a synopsis of the person that's running the Airbnb advertisement, which comes out to be one of the comedy club owners at the property of 5501 Gulf Boulevard. Just some pictures of the interior of the rental. And I'm going to go through these. If you would like me to stop, please just let me know.
Actually, let's hold off on substantive evidence until we get past the motion to dismiss.
Yes, sir. Thank you.
Mr. Denhart.
I hope to have heard you said, if we get past the motion to dismiss.
I said if we do, right.
If I may, Jim Denhart, I represent the respondent, Bayside Shops LLC, and its managing member, Janet McInerney, who is an attorney in Tampa, is present with us as well. And I have filed a motion to dismiss and an amended motion to dismiss on the basis of this case not being irreversible, irreparable. And it makes a substantial difference because if it is not irreversible and irreparable by code, by statute 162 and by the St. Pete Beach Code, the inspector has to issue a notice of violation, give a reasonable period of time for the property excuse me, to come in compliance, and then if it's not brought into compliance, go ahead with the proceedings. That was not done in this case. Had it been done in this case, we wouldn't be here because the violation was corrected on, I think, August 15th, the day after the notice of violation was issued. I've given to Your Honor and the city attorney the definitions of irreversible and irreparable, and would first start out and say, in my constitutional argument, I believe there's substantial vagueness in the St. Pete Beach Code. There is no definition of those two terms contained in the code. So a reasonable person, it's hard for them to know what's prescribed and what's not prescribed. The law, of course, says that generally criminal or municipal ordinances can be criminal in nature if they authorize criminal penalties. In this case, the fine could be $5,000. In Florida, that's the same as a third-degree felony, which carries a fine of up to $5,000. Section 3-16 of the St. Pete Beach Land Development Code provides that items that are a violation of the LDRs can be punished as a criminal case, as a municipal ordinance citation, up to $500, up to 60 days in jail. And that's in section 1.14 of the St. Pete Beach Code. This alleged violation supposedly violated the LDC, so criminal penalties could be imposed. I would point out that as to the definitions of irreversible and irreparable, and we heard a little bit about this earlier in the environmental case, but my definitions, and I've given to Your Honor the definitions that come out of Black's Law Dictionary, I've given it to the city attorney. And if you go down each one of these, irreparable is defined as being incapable of being rectified, incapable of being restored, incapable of being remedied, incapable of being cured, incapable of being regained, or incapable of being repaired. To be rectified is to set right, make it right. That was done in this case. It was corrected that day. No more short-term rentals. To be restored, the property restored is defined by Merriam-Webster dictionary as to bring back or put into a former or original state. This property was put back into the original state of not being rented anymore for Airbnb or any other kind of short-term rentals. Also incapable of being remedied, and I certainly would submit that the violation has been remedied. I mean, the earlier case today dealt with dunes. I was going to argue that certainly some environmental cases could be irreparable or irreversible if you chop down dunes, if you chop down mangroves. At one time I represented a client for chopping down a massive 80-year-old oak tree in Safety Harbor. I would have to agree that's irreversible, irreparable. But in this situation, it was not irreversible, irreparable. The incapable of being remedied talks about providing or serving a remedy for. There was a remedy. It was made right. And remedy even is defined as redressing a wrong. That was done in this case. The incapable of being cured, cured talks about to correct one or more legal errors. That was done. To regain is to get back to something in its original state. That was done. And to repair, again, is to remedy, heal, or to make right again. This situation was made right immediately. And again, it makes a big difference because if it's not irreversible or irreparable, then the code officer has to give a notice violation, a reasonable period of time for bringing the property into compliance, and then if failing that, if it's not, then we come before the hearing before the special magistrate. The irreversible, the other part of irreparable, means to damage so extensive or so great as to make it impossible to revert to an earlier state of condition, state or condition. And that's out of Merriam-Webster Dictionary. So I would submit that the code, first of all, in St. Pete Beach is too vague, and I think it has a constitutional infirmity for that reason. I will admit that after being involved in this case, city attorney, cities where I'm city attorney, I'm changing my code to put in definitions of irreversible and irreparable. I'm not saying the city can't do that, but right now they don't have it. So then, as we all know, you look to kind of the common everyday dictionary definitions, and there's not a common dictionary definition here that would support this incident being irreversible or irreparable. Even in the earlier case, Ms. Ogello found that, going over the dunes, that was not irreversible or irreparable. And that was, the hurricanes were in October. The damage apparently was done in March. In this case, property was cited in August. It was corrected in August. So I submit that the motion to dismiss should be granted. And you can't skip from going from a charge from irreversible or irreparable to saying, well, maybe there was another violation that wasn't, because it wasn't cited at that. And there wasn't the opportunity that's mandated by Statute 162 to be able to correct the violation. So I submit the case should be dismissed. Thank you.
Thank you. Ms. Stuprich, your response.
Your Honor, before you today is not, we don't have a criminal matter before you today. I think comments and references made to the code violations having some type of criminal nature to them is really just a red herring. This case is not being prosecuted in that regard. This is being prosecuted as a code enforcement violation for irreparable, irreversible harm. Also presented to you was reference to our prior case, which was environmental in nature, as being evidence of irreversible and irreparable, saying that Ms. Ogello had considered that as such. She's also, in other cases, viewed specifically short-term rentals as being irreparable, irreversible. But what it really gets to is the heart of the matter, which is the nature of the particular violations that are before you. Council has referred to the opportunity to remedy it, and has also made argument that in fact they has been remedied. But that is not the case, because these short-term rentals, they are transitory in nature. They are not of a continuing violation. To characterize it as subject to remediation or repair would require that rental to be ongoing. And then there would be a compliance period where you could then terminate it. These are instances that are transitory in nature. They happen, they cause harm, They're a violation of the code. In fact, Florida statute also segregates these type of violations from other violations that would be somewhat continuing in nature. There is no definition in state statute as to what irreparable or irreversible is in nature. The words in nature provide the discretion to the reviewing body to determine whether or not it is irreparable or irreversible. The statute does give some guidance in that it basically shortens the notice requirements to bringing it before the magistrate, indicating that it's a very serious thing, that it needs to have immediate resolution. The statute also gives an enhanced fine, again, showing that it is something that is very significant in nature and differentiating it from a reoccurring type of violation that could be cured. With that said, you know, the statute, again, it does give some indication of some factors that could be considered, but those factors are not dispositive of the definition of irreversible and irreparable. Looking at the gravity of the situation, the ability to correct, which is not present, and if there is any type of previous violation. But again, those are factors to consider in determining whether or not it is irreversible and irreparable. In this particular case, there are multiple violations that have occurred. And the fact that they have arguably stopped engaging in short-term rentals doesn't cure those prior incidents that were transitory in nature. Because they are transitory in nature, they are different. They are not subject to any type of cure, making them irreparable and irreversible. It happens, you can't stop it.
All right, Mr. Dewar? No, we're just talking about the motion to dismiss.
Yes, sir. In addition to what you just heard from the city attorney, I would like to add the following. This is from State Statute 16206. Can we zoom in, get a little bit closer on that, please? Which says if the code inspector has reason to believe a violation or the condition causing the violation presents a serious threat to the public health, safety, and welfare, or if the violation is irreparable or irreversible in nature, the code inspector shall make a reasonable effort to notify the violator and may immediately notify the enforcement board and request a hearing. So as I said, in addition to what you just heard from our city attorney, we had reason to believe that this violation was irreparable and irreversible, so we notified the respondent and immediately notified the enforcement board, hence is why we're here.
Okay.
So, thank you.
Thank you. Mr. Denhart, anything you'd like to add?
Very, very briefly, please. First of all, my motion to dismiss was in two parts, two arguments. The first part going to what was just argued about, well, this isn't a criminal. I understand this is not a true criminal proceeding. It's somewhat like it. It's a little bit akin to it. It's a little bit quasi-judicial. It's a little bit a lot of things. But forget that argument altogether and just go to argument number 2 in my motion to dismiss. And that's the one dealing with irreversible and irreparable. And what we just heard was, yes, that is what Chapter 162 says. And I remember when that came out back in 1982, I think it was, except I think it's Chapter 163 at that time. But it provides a method to try to stop things that are causing substantial harm and damage if the code inspector finds it to be irreversible, irreparable. And yes, in that instance, they can do it. But the statute also says, or the St. Pete Beach ordinance also says, that ultimately it's up to you to determine is it irreversible or irreparable. And that's section 22-279B of the St. Pete Beach Code. That if after due notice and hearing you find it to be irreparable or irreversible, you may impose a fine not to exceed $5,000. And then it gives a criteria that you must determine, which is the gravity of the violation, any actions taken by the violator to correct the violation, and any previous violations committed by the violator. Well, first of all, forget it being criminal, forget maybe it being vague, whether it is or not. It's not irreversible, it's not irreparable. Yes, they did give their notice and it stopped immediately. So the property, the day after the notice was given, was in the same condition that it was back before any short-term rentals that started, I think the testimony would show, if we get there like 6 months before. So I don't think we can be here.
Mr. Dewar, you have one more comment?
Based on what you just heard from the attorney, irreparable or irreversible means it cannot be undone. In this instant, what cannot be undone is the fact that I'm sure his client has not paid back or discounted or given back that money that they collected. That is what cannot be undone. The violation occurred, they collected that money, and that's why we're here, because that process was not undone. That's the
So let me ask you the
irreversible
question
part.
then. Does every case that you bring before the special magistrate involving short-term rental violations, are those all handled as irreversible and irreparable violations?
Yes, that's correct, sir.
All of them?
Yes, sir.
Yes, Your Honor. And again, the gravity of, there is a public policy, a very significant one regarding short-term rentals. And as you know, they are heavily regulated by the state and as well as the local governments in certain aspects. Before you today will be 33 violations. Let's go back to violation number 1 or number 2. Is there any way that those could be remedied? No, they happened.
Can I impose a fine for those violations?
Yes, you can.
Okay. Would that be an adequate remedy?
A fine is a penalty and not remedial.
All right. Let's deal with the amended motion to dismiss, which I had a chance to review this morning when it was handed to me. On the constitutionality issue, I will find against the respondent, Bayside Shops LLC. I don't believe this rises to a constitutional issue. The city ordinance is patterned after the state statute. State statute does not define irreparable or irreversible in nature. I did look before the hearing, search the Attorney General website to see if there's ever been a case that the Attorney General has opined on the definition of those two words, and I've not found anything there. I looked for state appellate court cases, didn't find anything there that specifically defined them, so I think that leaves it to common sense and using dictionary definitions, which are very helpful. For me, I think if we are looking at irreversible or irreparable damage, I think the case, the situation that Mr. Denhart mentioned is probably applicable. If I were to have snuck on the Masters, Augusta National yesterday, or not yesterday, going back about 10 or 15, 20 years ago when the Eisenhower tree stood 210 yards off the tee box on number 17 and cut it down the day before the tournament, that would be irreversible and irreparable harm, because there's really no remedy to put that tree that had stood there for many years, putting that back to its previous location and the growth that it had over the decades that it was there. So I would view something like that as irreversible and irreparable. I know I sat through Ms. Agello's decision this morning where she looked at an environmental issue dealing with dunes and found that those were not, any kind of disturbance of the dunes were not irreparable or irreversible. So to the extent that the constitutional issue has been raised, I'm going to find against the respondent on that. I think we get to my view that subsection 4 of the statute and the city code is a remedy that the city has for situations where there's irreversible or irreparable harm. And you have that option if you think it is that nature. I know the cases I handled previously for about the 2 or 3 years that I was sitting as the magistrate on various cases. I don't believe I saw too many cases that asked for damages for irreparable or irreversible harm. Most of the cases I handled were after the fact, where penalties were imposed based on daily violations, sometimes very substantial, into the several thousands of dollars, sometimes more minor matters. But they were all involved action that was taken before the case was brought, and the remedy that was suggested by the city was to impose a fine, which I did on a fairly regular basis on almost all of the cases that were brought before me, where I found the respondent responsible. So I think in this case, I think the question becomes, is the city prepared to move forward with a garden variety zoning violation case as we have before us today? And that is somebody who rented out their property on a short-term rental basis, where the zoning code, the LDRs, prohibited any kind of rental in that particular is it AC zoning district, I think it is. So I think that's the question, is if you're ready to move forward with that today. And I think I'd like to hear from both attorneys if that's what the issue is before me today. So I'll start with Ms. Duperich.
Your Honor, if you could just clarify for the record your finding. Are you making a finding that this is not irreplaceable, irrevocable, irreplaceable?
Yes.
You are?
Yes.
Interesting. Okay.
Well, thank you for calling it interesting, but my feeling is this is a garden variety zoning violation. I know it's only been Mr. Denhart's statements, but he has indicated both in writing and orally here today that the violation was remedied the next day. Don't know if that's the case or not. Certainly trust Mr. Denhart's word, but that's an issue that needs to be established factually. But I don't really view short-term rental violations as being irreparable when you've got the ability to stop them if they're illegal. If this were a situation where you could have 7-day rentals and they were doing for 3 days, there are penalties that have been imposed in previous cases for those, but I would be very surprised if they were found to be irreparable and irreversible, because they are. There's an adequate remedy at law in imposing damages. That's how you get landlords who are advertising on Airbnb and other online platforms to comply with what the local ordinance is. And I believe in this particular case, there is to be no rentals in this particular zoning district. I don't know if that's the case. I certainly defer to somebody from the staff to help me understand that, but I would think that my reading of the AC zoning district is that there are no rentals unless there is one very specific exemption for multifamily. And again, I'd have to go back and look at my notes on it, but I will, and I can find that if that becomes pertinent today. So, Mr. Dewar.
I'm listening to you, Mr. Tanis, and so Pete Dewar again on behalf of the city. You asked the question if Ms. Special Magistrate Ajello rules on these cases, which are short-term rentals, if they're irreparable and or irreversible in nature. And as you see there in paragraph 7, the Special Magistrate finds the respondent and the subject property were in violation of section 30.5 of the city's Code of Ordinance, as the use is not a use of right or condition in the zoning district. The rentals in violation of the code are determined to be irreparable or irreversible in nature, and the respondent is assessed $1,000 for each of 3 stays. Mr. Special Magistrate, with all due respect, I hear you, I understand what you're saying, but these cases have been heard previously to be irreparable or irreversible. As I mentioned, the act of renting these properties on a short-term basis, yes, they can be corrected after the violator respondent receives a notice from the city, but again, the act itself is not being undone, hence it being
irreversible in nature, right? And so, again, with all due respect, I would ask that you continue finding these cases to be irreparable or irreversible.
Your
based
Honor,
on the decisions in the
if
past.
I may also clarify, I mean, I would say that perhaps there may be some circumstances where a short-term rental, based on the facts in a particular case, could be an ongoing violation as you subject to remedy. That would be a situation where a rental is in the process and is continuing to be rented and the code violation comes to you. In that situation, you could terminate the rental within a short period of time, right there and then. But when you have instances that are transitory in nature, they happened, it stopped, you can't go back and undo that. And that, I think, is the distinction that needs to be made. If you can't go back and undo it, it's irreparable, it's irreversible.
Mr. Denhart.
Your Honor, I learned 50 years ago as a young prosecutor that when you've kind of won the argument, you're not supposed to keep arguing. And I certainly accept your ruling that it's not irreversible and irreparable, but now the city's saying, well, you can't undo something. I would point out that in the majority of code enforcement cases, they come up because of something like a junk or abandoned vehicle in a yard, overgrown grass in a yard, or something like that. Yes, somebody has an abandoned vehicle, they're required to give notice to that person and a reasonable opportunity to cure it, and if they cure it, then they can't go back and say, well, we want to fine it because it was there. That's not the way 162 was written. That's not the way the St. Pete Beach Code is written. Same way with a junk vehicle, overgrown grass, any other violation that's not irreversible or irreparable, their own code says that unless it's irreversible and irreparable, they must give the notice of violation and give a reasonable period of time for bringing the property into compliance. Once it's brought into compliance, there is no more case. It doesn't come before the magistrate. So I don't think, if it's not irreversible and irreparable, they can't say, well, we're going to change now. We gave you a notice of violation for being irreversible and irreparable, but now we're going to proceed under just a normal ordinance. They got to go back to square one and start over again if they're going to do that. Thank you.
So I think this case started off, there was a notice of hearing that was issued asking or directing your client to be here on September 9th, 2024. And it doesn't cite any particular ordinance as having been violated, but there's a reference to an affidavit that was attached. I don't think I saw the affidavit in the file, but then I see on August 14th, there was also an irreparable or irreversible notice of violation issued citing 38.5, stating that your client was engaging in an activity not permitted by the AC Activity Center District regulations.
The case started off, as Mr. Cruz testified earlier, with the irreparable or irreversible. The city has two different forms that they use, one for regular violations, one for irreversible or irreparable or irreversible violations. It started off, as he testified, on August 14th when he went to the property, when he observed the violation, and when he issued this notice. He elected the route of going irreversible, irreparable. There was no other violation cited.
So you think it's an either-or situation? I mean,
Yes, sir.
can I treat this as a standard violation like I've always done? And I agree with you, if it was a junk and debris, let's say somebody had a junk car in their backyard, and it stood there and it sat there for 30 days, and then the owner finally moved it, I think I'm hearing from the city that that's irreparable and irreversible behavior. Though I've never treated a case like that. I've treated it as a violation, much like you suggested I should, and I should penalize the person for having it been there. He had time to cure it, probably didn't cure it, in a certain period of time, but, to have it brought before the magistrate, but the magistrate has the authority to impose a fine for that kind of behavior. I think in this case, if it was just brought as a violation of 38.5 without the irreversible and irreparable language included in the notice, I'd be dealing with, we'd probably be done by now, because I would have found that your client, I think your client may be acknowledging that there was use of the property that was not permitted in the AC zoning district, but she corrected it immediately upon being notified. I still have the authority, though, to impose a penalty for the behavior that brought this before the magistrate. So,
I'm sorry.
yeah, go ahead.
Had it been a normal case, they would have had to give a notice of violation, and the notice of violation would have had to say, I believe, the code inspector, I believe that a reasonable period of time for, you've got to correct it by a certain date, whether it's 10 days, normally 10 days, 30 days, whatever. It would have been corrected within that time, and if it's corrected within that time, then the violation terminates. There is no violation. As all of us know here, the purpose of code enforcement is to obtain compliance with the code. It's not to penalize. Code enforcement has always in Florida, since it started in the early 80s, been to obtain compliance with the codes of the city. Had it been a normal, it's an either or, yes, I do think it's an either or. That's why they have two different forms. They elected this one. They didn't get past go on this one. If they want to go back now and say she's in violation now, then they've got to give her a reasonable period of time, and it's going to be, she's not in violation now, so.
So this notice was the first time your client was informed that there was a violation occurring at the LLC's property?
That's what yes, and that's what Mr. Cruz testified to. He showed you 3 dates, August 14th, August 14th, August 14th. Everything happened on one day. Everything was cured that day. There were no more rentals after that. Ms. McInerney went to her client or her tenant and said, you can't do this. And they canceled out all future rentals. There were no more rentals. It was brought into compliance the day that the original violation citation was issued, August 14th.
So you think that the form is what's prohibiting me from proceeding with this as a regular violation of the city code? Am I authorized to treat this as just a garden variety violation of city code for which I could penalize your client for having violated it before August 14th?
I don't think so, no. And I don't see the authority for that in the St. Pete Beach Code. Their code tracks 162 that says, under normal garden varieties, here's how you proceed. If you think it's irreversible, irreparable, then you can proceed this way. And they did not proceed in the first way, so no. Had they proceeded in the first way, this never would have been set for a hearing.
Okay.
Maybe the code inspectors disagree with me, but...
Yeah, and again, in the interest of making sure everybody has a chance to be heard, let's let Mr. Dewar discuss this one more time.
Sir, I take you back to 16206, paragraph 4, which says we have reason to believe that this is irreparable or irreversible. And it's not just based on the city's determination. As I just showed you, we have evidence and precedence that these cases, short-term rentals that we have, the city has zero tolerance policy for. These cases are now heard, and the precedent has been set by our sitting special magistrate that these cases are being heard as irreparable and irreversible. It's not just based on a first and a second take a guess at which notice of violation we'll be sending. We are sending these notices of violation that are titled irreversible and irreparable because of the precedent that has been set by the special magistrate. This is not just us picking which we're going to do eeny, meeny, miny, mo. That's not the kind of operation that we have here. It's a matter of...
Why not do that on your junk car in the backyard case?
Because as is correctly pointed out, you have the responsibility and you're given the opportunity to correct. It's not a matter of they didn't correct after they were notified. It's a matter of what you did within that specified time that the officer will prove to you that there was a specified time that the violation was occurring. That matter is not going to be undone, hence the irreversible aspect of this.
So the 30 days that the junk car was sitting in the backyard, how does that get, does that come into play then? If the owner of the junk car moves it off the lot the day that he receives the notice of violation, case is over, magistrate doesn't even hear it?
Correct.
You don't want
That would
to
be,
penalize him for having it there for the 30 days that it sat there in violation of the code?
it's not a matter of penalizing, as you're well aware. Staff and we educate all day, every day, right? The idea is funds have been collected by the respondent for the illegal act, and those funds that were collected will not be given back or refunded to the visitors that stayed on this property. We have made that determination, not just because of staff's involvement, but we also have a special magistrate who has ruled in favor of these cases being I&I. And so that precedence, because it's established, again, it's not an eeny, meeny, miny, mo, which violation notice we're going to send today. Any short-term rentals in the city of St. Pete Beach, because of the zero tolerance policy, we apply the I&I standard to those cases. These are not your garden type variety cases. As you're pointing out, a vehicle left on someone's property for 30 days, that case might never be heard by the special magistrate because that case can be corrected. In this instant, in these short-term rental cases, we have established precedents that these cases are I&I because of the funds that are collected by respondents, illegally so, because they're renting on a short-term basis, which is illegal, and those funds are not being refunded. That is the precedent.
Don't I get a chance to penalize the person who is illegally renting the unit by imposing a substantial fine that could be equal to the amount of rents that person collected?
Of course, I don't know if you can make that decision. I think that would be.
The city likes to send a message to people that try to rent on Airbnb illegally and VRBO and other online platforms by asking for a substantial fine. I don't think any of the cases that Ms. Agello hears, her orders direct the refund of money to those people who had the benefit of staying there in violation of the short-term rental regulations.
I mentioned the refund as it relates to the irreversible aspect of this. We're not expecting a refund. That's not our business, right? The idea is, what is the consequence for you renting your property illegally? And that consequence is to declare that these cases are irreversible and irreparable. And that is why there is that request for either $5,000, which is pursuant to the statute, but it's normally deduced or deducted to $1,000, which, as you just saw, is normally Mrs. Agello's ruling.
Okay.
Thank you.
If I may have...
Mr. Denhart.
I would point out the city does have a remedy here. As you're aware, codes can be enforced one of three ways. They can be enforced through a code enforcement board or special magistrate. They can be enforced by injunction in circuit court, and they can be enforced by local ordinance violation issued in the county court. The city has a remedy if they want to punish for a past incident. They can charge a local ordinance violation saying that on X date, somebody violated the code by renting short-term rentals. That citation then is returnable to the Pinellas County Court, and a judge hears that, and if the person's found guilty, then they receive a fine for that. Code enforcement through the Code Enforcement Board and Special Magistrate is for the purpose of bringing the property into compliance with the codes. And so the city so far has just gone this route. I'm not saying that they may not have the option to issue whatever 30 different local ordinance violation citations for each, however many there are that they say were rented before my client had any knowledge of it. They maybe can do that and go back. They're still certainly within that statute of limitations for that. So they have a remedy for past things, just like they would have a remedy for saying a junk car was on somebody's property for a certain date, but they corrected it. Well, the city still could charge a LOV, a local ordinance violation, in Love Court, whether it's called here. And they could go out on Thursday and they could try to receive a fine for each day, but they can't go back for the junk car and the overgrown grass, and now say they want you to impose a fine because something happened before this started on August 14th. Thank you.
Your Honor, the city does have different remedies in these type of cases. We have chosen to come forward with this case as irreparable and irrevocable. The prior violations that occurred, there are 33 of them. There is no way that we can go back. The property owner cannot go back and cure those. They're done. They're irreparable, irreversible. Going forward, I think there's been testimony that she understands, or the entity understands, that they should not be renting these on a short-term basis, but that's prospective. We're here because of the 33 violations that are irreparable and irreversible that occurred in the past.
Okay. Anything else?
I'll stay seated.
Okay. So let's do this. I don't necessarily think we need to go to proofs at this point, do we? Is there anything else? Mr. Cruz, you were going to show the list of violations. They're in the record. I've seen those. I don't think Mr. Denhart or his client will be disputing what is part of the record, correct?
We stipulate that there were short-term rentals basically between January 1st or December 31st and August 14th. My client had no knowledge about it until she received the notice of violation on the 14th. It was immediately corrected on the 15th. We will stipulate to that.
Any objection to that stipulation?
Oh, and also that she received no money. It was done by a subtenant.
Well, there's a lot to be packaged there. If there's a stipulation that the rentals occurred, well, I'm not sure what your attorney is saying. If you could just restate it. I'm asking specifically what your stipulation is.
Come on up to the podium, Mr.
Your Honor has asked.
And again, I have all day, so we can go through a full set of proofs on this if you'd like. But what I'm trying to do is sort this out as far as the I&I issue, as to whether I'm allowed to even hear a case like that. If I were to find it not to be irreparable or irreversible, the question is, can I just hear this as a garden variety case? Has your client received notice that the city is pursuing a remedy for violation? I think the I&I part of the statute is a remedy available to the city, along with all other remedies available to the city, and that would include the imposition of a fine for each violation, and that there's a cap on that, a daily cap, and we could go back and take the 11 violations that have been alleged, calculate the number of days, and the city would ask for a fine on that, and I would most likely take the city's request, your request, and probably find something that I think is reasonable in between those two numbers, and impose a fine on your client for the past violations that occurred, even if your client did not have actual knowledge. And I heard that, is it Ms.
McHenry? It's McHenry.
McHenry, yeah. And again, this is not an issue I'll take as fact at this point, but it sounds like Ms. McHenry did not have notice that this was going on, had a tenant who was taking advantage of the situation and was leasing it out unbeknownst to her. Again, no defense, other than I can take that into consideration when fashioning a penalty. If this was a planned activity by the owner of the property, the LLC, then I would probably take a much more different, I'd take a different approach to it. But I think that's the issue. And if I wanted to proceed on this as a garden variety violation where I can impose a fine for each violation, I'd be prepared to do that today, because it sounds like we did have violations. We're not disputing that. It's just your client is indicating that she was not aware of it, which I can take that into consideration too. And I would issue an order, and I think that would probably end the case. But it sounds like if my only choice is to find this to be irreparable and irreversible, and I find that it's not, then that ends the case. And I don't think that's where the city wants to go with this.
No, but going back to the possible,
I want to go.
The possibility of a stipulation, there is documents in the record that code has provided evidencing the 33 instances of rental, short-term rental of that property. So I would be okay stipulating that there was short-term rental 33 times, as shown in the agenda materials, I think beginning on page 31 through 41.
So that's under the evidence tab, and I see several colorful pictures and red boxed exchanges, which I assume were on, was it Airbnb, this platform? Yes. Yeah, so, and again, I see 33 different exchanges that took place, and I haven't read each one, and I could, but I'm assuming that those were efforts at rentals that actually materialized prior to August 14th, 2024. So I guess that's what Ms. Stuprich is asking you to stipulate to, that these were actual violations that occurred prior to the notice being issued.
We have no knowledge of those, so I'm not, I can't dispute those. My client was not involved in that. She had no knowledge of it. She was not involved other than being the managing member of the LLC that owns the property.
Okay. All right. So,
but I still don't.
Is that a stipulation?
I won't treat it as a stipulation. I'll just treat it that the city has submitted evidence that is not contradicted. And
I can't contradict
that
it.
as
We have
part
no
of my.
knowledge.
Yep. All right. What I'm going to do is I'm going to take the matter under advisement. I obviously have, I probably am deviating from what Ms. Agello has decided in the past on these cases, and that's why I do want to look at it. I want to see if I can find some case law. I am definitely ruling that this is not a constitutional issue. Obviously, I think
I understand.
sounds like you and I were in law school at the same time, back in the 70s and early 80s, maybe. For you, not for me.
Not for me either.
Okay. And if there's a remedy, if there's an answer outside of deciding a case on a constitutional basis, then you should do so. And I think in this particular case, we have the statute under Chapter 162 having been in existence for many years, since 1980s, and those words have appeared in there without full definitions, and they've been applied by many magistrates in many cities throughout the state of Florida for many years. And at this point, there's no case law finding them unconstitutional. Mr. Denhart, I'm not saying you have not found a new issue to raise after 40-some years of this statute being in existence, but I'm not the one that's going to blaze that trail and find it to be unconstitutional. I think the question for me is whether this is an irreparable and an irreversible situation. If it is, then I allow the city to move forward, and I'll find in favor of the city in a case like this. If I find that it's not irreparable and irreversible, then I'm hearing that from you that I'm not allowed to take the next step and just treat this as a regular code violation case and impose a penalty for that. Is that correct?
I believe that if you find it's not irreversible and irreparable, we should never have gotten to this part of the proceeding.
All right.
Therefore, no fine.
All right.
I would just like to mention one other thing, if I could, and I'm not sure. Need to think this through a little bit, but I would point out again to you under Section 22-279B of the St. Pete Beach Code, it says that if you do find irreversible and irreparable, it gives your marching orders and says, then in determining the amount of fine, if any, which is used right in their code, the special magistrate shall consider the gravity of the violation, any action taken by the violator to correct the violation, and any previous violations committed by the violator. Now, I'm a little bit questioning here where we're heading today, because obviously I need to build my record and have my testimony. If there's any chance that you're going to be entering a fine, I would like to go ahead with the hearing just so that all the testimony is in the record. And I apologize for having to do that. But
no, I understand that, because you will have the opportunity to take this up if you'd like to.
Okay.
And your client is willing to participate in an appeal of my decision. Why don't I do this? If I find that the case is going to go on, I'll reschedule it for another hearing. And I'll try to pick a date that's convenient on the regular call date, so it doesn't necessarily have to be next month, because I sense that there's no urgency at this point, since there's no allegation that the rentals are continuing. So it would probably be either next month or the month after, where we'd reconvene and then do proofs at that point, and let the city present its full case. You'll have an opportunity to present your case, and then I can make a decision on that.
Thank you.
Okay?
And
So,
I do have several trips out of the country coming up this year, so I'm not sure.
it's the second Monday of the month, right?
know.
It's still the second Monday of the month for all the hearings, so, yeah, why don't you look at your calendar and tell me,
I'm sure we can work out a date if it gets to that point.
yeah, we definitely want to keep it on the regular call, though.
I
which
just
would
want to be able to have some input on the date of the hearing, because
Absolutely, I'll have Ms.
this
Stuppers
has bounced
contact
around
you,
both
and then
for
you can
them,
work that out.
for hurricanes, and for me for illness, so.
Right. All
Thank
right.
you.
Very good. All right, matter taken under advisement, both the motion to dismiss and the case in chief, and if needed, I'll reschedule another hearing where we can move forward with the I&I case. Good.
Your Honor.
Yes.
With all due respect, so then we would be renoticing the case for the future hearing? Or you're going to continue it?
My order will include a new hearing date, and I will consult with Mr. Denhart and Ms. Stuppridge and Mr. Dewar on scheduling that. Whether it's the second Monday in May or the second Monday in June, we'll have to figure that out. Obviously, there's no reason for me, to delay it. But,
My concern would be having to repost the property, continuing it to a date certain, if we could.
I,
As long as there's notice to me, I will
Yeah.
agree that that's notice that complies with 160.
yeah, there's
So
no
he's
need to
waiving.
repost any of the, we're still working off the original post that was posted on August 14th of 2024.
So he's waived
It's just subject to,
your notice?
yeah, I think he has notice now, and his client is here, and she has notice, so, and if I could get the spelling on your last name, Ms. McHenry, please.
Yes, it's Mcenery.
Okay,
Thank you.
thank you. All right. There are other people in the back. Are they here for anything I have?
Well, we're here for the case. Potential witness, counsel for witness, no need to.
All right, okay. I wasn't sure if you were, okay. And that concludes today's special magistrate hearing.
Thank you.
Thank you.